break has been called this afternoon in the William Riley Gaul case out of Tennessee, the case of a football player who went on to college who's accused of murdering his cheerleader ex-girlfriend. Julie Rendelman is here in studio with me to break down some of what we've heard this afternoon. Julie, we've got the friends up on the witness stand. These are the defendant's friends. He was talking with them about this case, about this shooting, and whether or not he was involved right before police swooped in and arrested him. These friends helped lead the police to the defendant and probably are responsible for the weapon the state alleges was involved in this being preserved because the defendant wanted to throw it in the river. You throw something in the Tennessee River, it's not going to just pop up the next day.
That's true, although, and I'm certainly not blaming the kids, but apparently at least some of the witnesses, his friends, knew that he had a gun prior to the death of this young woman and didn't call the police because they were too loyal to him. And so, you know, it's tragic that they didn't come forward sooner because perhaps this wouldn't have happened. But yeah, he had these friends. These friends, in a sense, turned on him. Thank God they did. And I think what's most important is the video that we hear, which establishes that the defendant is willing to even lie to his friends about the scenario of what transpired leading up to and after the death of his ex-girlfriend.
Gary Gerstenfield is on the line with us from Washington, D.C. Gary, good to see you again. I want to ask you, do you think that this defense holds water? The defense is saying, okay, look, this defendant, Riley Gaul, shot the gun. It went into the wall of the house. They're admitting that. They say he's the trigger man. They're not trying to back out of that anymore. But they're saying it's a recklessness situation, not murder, not anything where he intended to have her dead. Does that hold water? Is it plausible? Is the jury going to buy it?
Well, is the jury going to buy it? I mean, I wouldn't want to bet the farm that the jury's going to buy that. He fired the gun into the wall exactly where his ex-girlfriend is sleeping. So, you know, is that first-degree murder? Firing a gun into where you think somebody is sleeping probably does meet the standard of first-degree murder. On the other hand, the optics are that he was extremely emotionally distraught. He had created this craziness earlier about the kidnapping, and then probably is the man in black. There's an episode where some guy shows up at the house and scared his scared Emma Walker. That was him, although the defense attorney at this point, I guess, saying that, but I'm not sure why. So there's some bizarre behavior clearly being clearly going on by Riley. The defense has to show that behavior that Riley's exhibiting from his optics, from his perspective, is recklessness and not intentional. I think in order to make that case, they're going to have to put him on the stand.
Well, you know, I was wondering that, but we didn't get a promise right out of the gate during the openings that he would, so perhaps we will, but we don't know for sure. Look, I want to put this conversation on hold. I want to show everybody, in case they missed parts of it, the recording. This was a secret recording. Some of those friends who have been on the witness stand made of the defendant. He talks about a lot of things. Let's start near the beginning. That was just some of this secret, surreptitious recording that friends of the defendant here, Riley Gaul, made just before police ultimately arrested him and charged him with murdering his cheerleader ex-girlfriend. Julie Rendelman is here with me. Julie, look, these are the words of the defendant. Oftentimes juries give that a lot of weight. It's hard to get out from underneath it. And look, even if some members of the jury believe the story that his defense attorney told, this is a different story. So how many different stories have come out of this particular defendant?
That's why I think he's going to have, you know, we talk about him taking the stand. I think he'd have a lot of difficulty taking the stand because he has a lot to explain if he takes the stand. And not just explaining how it is that he ended up killing his ex-girlfriend, but explaining why it is that he felt the need to lie to his friends in regards to what transpired. And so, you know, obviously the argument is that the statements he's making are a consciousness of guilt. You know, one can argue, because I think there is some room possibly for reasonable doubt in this case. We haven't seen it all, and I think there's an argument to be made that throughout this trial, what he's trying to do is be the hero, and trying to do everything in his power to try to get her believe that he needs her help, whether it be that he was kidnapped or someone close to her was kidnapped or there's a man in black that's going to hurt her. And so all the things that lead up to him killing her could arguably fit into him trying to be the hero. However, the argument against that is exactly what we talked about earlier, which is that the shot is fired directly into the bedroom that he knows where she sleeps and he knows how she sleeps. And so the argument, obviously, for the prosecutor is that it's clear that he intended to kill her because of where that shot was placed.
Yeah, Gary Gerstenfield is on the line with us from Washington, D.C. Gary, what do you think? You got multiple versions of the story out of the defendant. He's telling his friends a couple different versions of it. He's raising this scepter that maybe she shot herself, okay, which was apparently one version of this that was going around. Right. Well, that doesn't make any sense based on any of the evidence that has since come out. And look, maybe that was an early version of this where rumors are swirling in the community or whatnot. Maybe he was trying to play off that. But look, at this point, his attorney got up there and said, this guy, Riley Gaul, is the trigger man in this case. So right. I think a lot of jurors are probably just going to look at this and say, okay, look, if that's the case, if this was some kind of reckless endangerment, he shouldn't be spinning all these yarns, trying to ask the friends to help him throw the gun in the river and all of that. Do you agree? Do you disagree?
I agree with Julie. I mean, and you, Aaron. The problem with whenever you have secret recordings and you have a story that's different than the narrative that you want to play in your defense is you have to explain it. And like I said earlier, if you're trying to explain that this was an unintentional shooting, or at least unintentional killing, but it was intentional, I meant to fire the gun to scare her. It's part of this ongoing narrative of trying to win back the love and affection of this woman. I tried kidnapping myself. That didn't work. Then I tried to scare her. That kind of worked, and apparently it did. He did apparently get a phone call from her. So now I'm going to try to scare her more. That kind of fits into the defense's narrative. The problem is then you get the secret story or the conversation where we're now trying to create a different story. And the other problem with that is he doesn't seem very upset at all. I mean, one of the problems is when you're calculating and you're telling a lie to your friends and you sound very cold and very methodical, it takes away any sympathy that a jury might feel towards a young guy who otherwise looked like he had a promising future. Look, he's playing college football. He's a nice-looking kid. He's, young love. Some Romeo and Juliet thing going on. I mean, you kind of see some sympathy. But when you hear this recording and you listen to it, you become somewhat cynical about his now position of, hey, I was very upset. I just wasn't thinking. Because even after the shooting, he's coming up with this story, which is obviously a distorted fact from what he wants to portray now, and certainly distorted from what really happened.
Yeah, I think we're going to cut back to court here. Gary, Julie, appreciate your analysis here. The judge and one of the attorneys are having a conversation right now. We don't want to miss that. Another break here in the Riley Gaul case out of Tennessee. Julie Rendelman and I are having a big argument here, and Gary, I'll bring you into this as well. What's the logic behind the defendant's plea on the recklessness charge, but not to the rest of the charges he faces? I've got an analysis of this up on Law&Crime.com for those of you who haven't taken a look at it. It's certainly there. Julie, you think this just makes absolutely no sense whatsoever.
I'd like some. Maybe Gary can explain it to me better than you've been explaining it to me, because I do not understand how it benefits the defendant to, I guess the argument you're making is that he somehow takes responsibility for the lesser included, but why can't he argue in front of...
Well, it's not a lesser included, it's a separate charge.
The lesser count. So why can't he just articulate that to the jury? Listen, ladies and gentlemen, he committed a crime. He's the person that shot her, but he did it recklessly. I'm not understanding how that pushes their position ahead. Gary, do you have any thoughts? Maybe I'm missing something.
Yeah, Gary, what do you think? Should he have told
let him answer. Let him answer.
Okay.
I think Julie makes an excellent point. So what, when you get lemons, you try to make lemonade. So we have a dead 16-year-old beautiful cheerleader, and we have clearly a homicide. There's no question about that. You're in a Hobson's position if you bring the kid on to testify, because as soon as he tries to testify this is reckless, he is going to be cross-examined like crazy about this secret recording and about the fact that he was acting so, he's creating new lies right after the shooting, and he's lying to his friends. They don't buy his story. It looks like he's trying to be manipulative and controlling, and frankly a liar. So why would you concede an important point by pleading guilty to anything at this point in the trial? I guess you're trying to move the narrative forward that he is taking responsibility for the recklessness aspect of the case. But again, I also happen to agree with Julie that you should do that in closing.
Okay, so yeah, that's where we're at here. I mean, it's one thing to argue it in closing and just say, hey, look, check the box for this charge because he did it. That's one thing. It's another thing to actually just enter the plea on it. But, we covered the War Machine case here last year, which is the case of an MMA fighter who was accused of viciously attacking his girlfriend, Christy Mack. And they used that tactic, Julie. They got up there and said, oh, yeah, check him guilty on this one, but not these other ones. And what did the jury do? They convicted him pretty much of everything across the board, as I remember.
Well, the evidence is the evidence. So I don't know the fact that he's going to plead to a lesser charge is going to get him out of the intentional or the felony murder. I mean, if you compare this case to the Great case, is it the Sean Great case that we're following? He pled guilty to some of the charges there, too, in the middle of the trial. The argument there is a little different because the argument there is the reason he did it, although I don't buy it, is that he wanted to not shove some of the evidence in
the other
cases.
Reason behind it is because he didn't want certain pieces of evidence to get in front of the jury.
So there was much more of a tactical situation, certainly by his defense attorneys in that case. This one's very different. This is a situation where all the evidence is coming in, whether it's the intentional or the reckless. And so to merely say to the jury, hey, he took responsibility for the reckless, if I was the juror, I'd be like, hey, it's my decision what he did. It's not his decision to plead guilty. It's let me decide what the evidence is.
I get that. Look, I mean, so Gary, you be the judge of the argument of Julie and the argument of.
I think he's already.
No. I've got another piece of this to articulate here. So Gary, I think it's because we're sitting in Tennessee. We're in a more conservative state. Julie will react to it with all sorts of New York City bravado and say, no, I'm the jury. I want to decide that. In Tennessee, people on that jury might look at this and say, you want to know what? That young man accepted responsibility. They might be more apt to give him credit for it.
Well, look, Aaron, like I said, when you got lemons, you try to make lemonade. They want to push a narrative forward that this was a reckless, horrible incident. But I do want to touch base on one of the problems that Mr. Stone's going to have arguing this reckless homicide. When we talk about reckless homicide or the elements of reckless homicide, think of it as misfiring a gun. You're loading a gun. Your friend's standing in front of you, and the gun goes off. That is a very classic example of a reckless homicide, where your conduct was stupid and you're drunk and you're with your friend and you're playing with the gun goes off and your best friend gets killed. That's an example of reckless homicide, where there was no actual intent to kill your friend, but the conduct was reckless and it resulted in a homicide. It resulted in a death caused by something other than a natural event. That being said, this is a case where the boy shows up at the house. Riley shows up at the house with a gun, and he's asked questions about how to get fingerprints off a handgun. I mean, that's a horrible fact that the defense is going to have to deal with, that alone. And then he points the gun at the direction of where he knows his girlfriend to be sleeping and then fires the gun. How does that constitute the reckless that we talk about in a reckless homicide? So sure, they were trying to push this narrative, and maybe they're trying to start it as early as they can in their case. It's going to raise an interesting issue about whether this kid testifies or not. If you want to push a reckless homicide where you pretty much have all the elements of first-degree murder, you really got to put that kid on. The problem is then you're facing a gruesome, horrible, stomach-churning cross-examination. As a defense attorney, that would be a nightmare.
Well,
Yeah.
Well,
No,
I don't. I'm going to put a pause on this. We're going to go back and listen to a little bit more of this secret recording that the friends made of the defendant while we're waiting for things to pick back up again. We heard from the prosecutor that he has a couple of witnesses that are somehow associated with this university, or this college, I should say, where the defendant was apparently a freshman. So while they wait for that to all play out, let's take a listen to the secret recording of the defendant himself. More of that secret recording of the defendant himself, the recording made by friends, apparently at the bequest of police somehow in this case. I want to ask about that. What's the legality of this secret recording of the friends? Is this deputization? We know it got in as evidence because it's there. So Gary, Julie, what do you think? Let's break this down legally. How is it that the friends are able to secretly record him, apparently without him knowing about it?
I mean, I'm not sure, what the law is in this state, in New York. In this case, the one thing I did catch is that, and you said that you believed he has an attorney, but he's not in custody at the time this is happening. So there's not the argument of custodial interrogation, although there
Which
could
requires a Miranda analysis.
Exactly, but there would be an argument to be made, as you said, that you believe he has an attorney at that time. So if he has an attorney, there's an argument to be made. If these kids are working for the police and he has an attorney, is there an argument to be made that no one was allowed to speak to him without his attorney being present?
Well, that sounds an awful lot like the situation where somebody's in jail and then the jailhouse snitch is specifically planted so that police can try to get information. And in that case, that's a custodial interrogation. But here it's not custodial.
There's also
right,
and there's a difference between questioning somebody and then just simply being present when someone chooses to speak. There's a delineation. I assume that they had some type of hearing prior to the trial to establish that, in fact, this should come in. But I just don't know the specific law there.
Yeah, and of course you've got recording laws, and I know the majority of states are, hey, look, if it's a public place or there's a recording device present, then a recording can be made.
And there's one-side consent. In New York there is.
There are a couple of states that have slightly different versions of that. I think Massachusetts is one, and I think Illinois is the other one, where the device, where it's sort of judged through a different standard. But, it raises questions. I mean, how do they record the video? I'm assuming it's on a phone like this. I mean, pretty much everybody walks around with a movie studio in their back pocket now.
Right. But that's a whole other issue. That's kind of the advent of social media and how we're able to, record or do anything. Look, at the end of the day, I don't know if they even needed this in order to establish his guilt. I think all they really needed was for them to be leading him to the disposal of the gun. Without any video of the conversations, I think they would have clearly had enough to go forward with an intentional murder against him.
Well, Gary, you're still on the line with us here. Some reaction to that recording is coming in that this guy, this defendant, just seems cold and calculated, and he is not a sympathetic character in that recording. Do you agree with that?
Yeah. See, from a defense point of view, and maybe Julie and I look at cases a little bit different because we all have our own optics when we look at a case. A prosecutor looks at a case from what elements they need. And in defense, we tend to look at what emotions we can create because we often can't control the facts of the case, and that's more the prosecutor's job. Our job sometimes is to try to create emotions and feelings, and particularly in this case, emotions and feelings are going to be really, really important if this guy's got a chance in hell of actually, not walking away with a murder one conviction. That being said, the recording by itself is not a problem. It's a one-party state. Only one party needs to know that it's being recorded. It's not an interrogation that requires Miranda rights to be given because you're not in a custodial relationship and the police are not asking the questions. And he does not have a belief that he can't leave, which is a fundamental requirement. Police can question you and not give Miranda as long as you don't believe that as long as you believe you could walk away, as long as you believe you're not being held against your will. That's sort of the custodial interrogation component. So that's not a factor in this. But when you see him sitting there calmly, and he's using some bad language, and he's just sort of sitting there very relaxed, and this is right after the death of his girlfriend, and he seems so at ease and so easy spinning lies to his friends, and the fact that his friends are recording the conversation, which tells you sort of where they're coming from, which is they don't, obviously this is a betrayal on their part, which goes to show that they don't have great affection for him. The fact that this is all coming together, I think, really does hurt the defense in ever trying to make a successful play for this reckless homicide argument that they're stuck with.
Well, they're trying to go for reckless endangerment, actually, here. Basically, what that is just, and I've got this on Law&Crime.com, the guilty plea was for placing another person in imminent danger of either death or serious bodily injury, and it's enhanced because it was fired into a house. Okay, that's a Class C felony, and were firing into the house, the punishment would be about 3 to 15 years and a fine of up to $10,000. That's the guilty plea. I mean,
Right.
if he goes to prison for 15 years and beats either the murder premeditated or the felony murder charges, which are life sentences, either with or without the possibility of parole, I mean, that would be a huge win. But really, that's all they're trying to get at. And I go back to one disturbing fact. If the defense theory of this case is correct, that he's only trying to scare her in yet another in these bizarre series of attention-getting episodes. If he's just trying to scare her, why is he shooting right where she's sleeping, right where the bed is positioned? If he's trying to scare her, why isn't he shooting at the garage or somewhere further up on the wall, not where someone is actually sleeping? If he wanted her to survive this and be scared and somehow run back into his arms so that he can be the knight in shining armor, why is he shooting where she's sleeping?
But at the same argument, and then someone can cross-examine me on this one, is that if he's intent on killing her, why is he shooting through a wall? I hate to go back to Tex MacGyver, but why is Tex MacGyver shooting her through the back of a seat? If you want her dead, then you're going to go to her and shoot her in the head. You're not going to hope that the wall penetrates enough that it gets to where you want it to go. So
he shot twice. One went into the 2x4 or whatever was supporting the wall, and then the other one is the one that went through the wall.
Right, but you're still having to go through a wall to do that. Now, I have to say on the other argument, as the prosecution might argue, is that he was desperate to try to see her. There might be an argument to be made that part of the reason he was so desperate to come in contact with her was because he planned to kill her, and so he never had that option. No one was allowing them to be together. The parents were allowing it. She wasn't allowing it. So in a sense, his only option of killing her was this way, and to kind of hope that his bullet penetrated where he wanted to. Who knows?
Maybe they will go that way. We'll have to wait and see. Look, I want to listen to a little bit more of this secret recording that was made. Apparently, it was made from a device that the police had given to the friends. It was some kind of a key fob camera, and that's how they made this recording. Interesting tactic. That's how it rolled out. Friends made the recording. It was played in court today. Let's pick up where we left off.